People be Noah Hindman. It's two file numbers, 25-6965FC and 25-7052FH. Counsel, you want to state your appearances beginning with people?
Melissa Goodrich, Blount County Prosecutor.
Good afternoon. Thank you. Revoked, Mr. Hinman.
All right, Mr. Gurmurthy, we're here for a docket call, and what's our status on these matters?
My understanding, Judge, is we've got this resolved. Mr. Hinman would be entering a no contest plea to in both files. There would be to amended count 1, accosting a minor for immoral purposes pursuant to MCL 750-145A. Both are 4-year felonies.
Okay, we have.
I should also state, Judge, HYTA is not part of the plea agreement, but I do intend on asking the court for HYTA consideration, and I'll address that when the court's ready, Judge. If you need a separate petition filed, or if you just require a request to be made on the record.
Yeah, how I would do that is I wouldn't need a formal petition. Just in your sentencing presentation, you can make that request. You're always welcome to submit a written sentencing memo if you wish, but I don't require it. I mean, sometimes if I have a heads up, then, you know, at least my head can kind of start getting there. So if you're able to submit a sentencing memorandum, that might be helpful, but I don't require it.
Yes, sir.
All right, do you consent to the filing of the amended information in both cases?
I do. And I would waive formal reading of the information as well, Judge.
All right, and the reason for a no contest plea would be what?
Potential civil liability.
And do the people consent to that plea?
Yes.
All right, and the prosecutor is going to present your affidavit to mark in the files. Any objection to my consideration of that as the factual basis?
No.
All right, Mr. Hinman, would you please stand and as best you can raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Okay, you can sit back down. Be careful, it hasn't turned too much on you. All right, are you Noah Isaiah Hinman?
Yes, sir.
Okay, Mr. Hinman, in a no contest plea, I won't ask you about what happened. I'll review some documentation, but I'm going to ask you lots of other questions about the process. So I want you to listen carefully. If you have any questions for me, please ask them. If you need time to talk to your attorney, you just let us know. We can put you in a breakout room and let you talk to your lawyer anytime you want. I have to advise you the maximum penalty for these charges. In both files, you're offering to plead no contest to a count of accosting a minor for immoral purposes. Those are felony crimes punishable by a maximum of 4 years in prison and or $4,000 fine. And they are registerable under the Sex Offender Registration Act as a Tier 2 offense. Unless you have a prior conviction, then it would be a Tier 3 offense. And there's also mandatory AIDS and STD testing. And Ms. Goodrich, would this be concurrent sentencing?
Yes.
Okay. All right. Do you understand the maximum penalties, Mr. Hinman?
Sure.
All right. Now, if I accept a plea, you won't have a trial and you'll be giving up the rights that you would have had at the trial. Do you understand that?
Sure.
I want to remind you of what those rights include. It includes the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. Do you understand that?
Sure.
You also would have the right at that trial to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order those folks to show up. Do you understand that?
Sure.
You would also have the right to testify in your own defense or to remain silent and not have your silence used against you at all. Do you understand that?
Sure.
Do you wish to give up all those rights and enter a plea under this agreement today?
Yes, sir.
If I accept your plea, you give up any claim that it was caused by promises that aren't in the plea agreement or by any threats. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission to appeal. You would do so by filing an application. And the kinds of issues you could raise after you plead guilty are very limited, much more limited than if you were convicted after a trial. Do you understand that? The plea agreement provides in exchange for your plea of no contest to accosting in both files, the prosecutor will dismiss the original charges. Do you understand the terms of that agreement? Yes, sir. And Mr. Gurmurthy, is that a full, fair, and accurate statement of his terms?
Yes.
Ms. Goodrich?
Yes.
All right, Mr. Hinman, other than the plea agreement, has anybody promised you anything to get you to plead guilty or plead no contest?
Sure.
Has anybody threatened you to make you do so?
Sure.
Is it your own free choice to do so?
Yes, sir.
Knowing all this, in file 25-6965, how do you wish to plead to the charge in count 1, accosting a minor for immoral purposes, guilty, not guilty, or no contest?
No contest.
And how do you wish to plead to the charge in 7052, accosting a minor for immoral purposes, guilty, not guilty, or no contest?
No contest.
All right, I'm going to review what's been marked as a joint exhibit in both of the files. Okay, and I do find on review of the joint exhibit in both files that it does establish a factual basis to the greater offense that's being dismissed, and therefore I can accept the plea to accosting as a lesser offense. Mr. Gurmurthy, are you satisfied with the factual basis that has that?
I am, Judge.
Ms. Goodrich?
Yes.
And Mr. Gurmurthy, are you aware of any other promises, threats, or inducements?
Not other than what we place on the record, Judge.
And Ms. Goodrich?
No, Your Honor.
And Mr. Gurmurthy, do you believe I've fully complied with the requirements of MCR 6.302?
Yes.
Ms. Goodrich?
Yes.
All right, well, Mr. Hinman, I find that your plea is knowingly, understandingly, and voluntarily made in both files, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I hereby accept your plea of no contest in both files. We'll schedule sentencing for, would you be available, Mr. Gurmurthy, on October 7?
I wouldn't, Judge, but I think I could do October 21st.
Okay, that's fine. We'll schedule October 21. Do you prefer morning or afternoon for in-person sentencing?
Afternoon would be fine, Judge.
Okay, we'll schedule this then for sentencing on October 21st at 1:10 in the afternoon. And Mr. Hinman, it'll be necessary for the probation department to prepare a pre-sentence report for me, so I know more about you than what I just read on these affidavits. So you're ordered to cooperate with that process. Anything further from the people?
No, Your Honor. Thank you.
Anything further from the defense?
No, thank you.
You may further now.
Thank you.
Yep.
Reiterated his permission that I sign on his behalf. The agreement would be that he pleads guilty to count 1, delivery of meth. In return, prosecution agrees to dismiss count 2, and more significantly, the drug penalty 2nd, as well as the habitual 4th offense. There's an agreement for restitution for $100, and there would be a weapon disposition if applicable. That's not applicable here, Judge. Thank you.
Okay. All right, thank you. Mr. Pulowski, would you please raise your right hand for me?
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can put your hand down. Mr. Niagos, do you consent to the filing of the amended information that I've been presented with that eliminates the drug double enhancement?
I do, Your Honor. Thank you. And we did receive a copy of that as well, and we would waive its formal reading. My client's aware that all the supplements are being dismissed along with count 2.
Okay, thank you. All right, Mr. Pulowski, a guilty plea hearing is an important event because it includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, ask me. If you need more time to talk to your attorney, let me know. I can create a breakout room for you.
Okay,
The charge of
Thank you.
delivery of methamphetamine is a felony. It's punishable by a maximum of 20 years in prison and or a $25,000 fine. Do you understand that maximum penalty?
yes, sir.
And you are on parole, is that correct?
I was,
Oh, you were, have you been discharged at this point?
yes, Your Honor.
Okay, all right, because this would be a mandatory consecutive to parole, but if they have already discharged you, that wouldn't apply. All right, Mr. Pulowski, if I accept your plea, you won't have a trial of any kind and you'll be giving up the rights that you would have had at trial. Do you understand that?
Yes, Your Honor.
I want to remind you of some of the important rights that includes, including you'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You would have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You would have the right to testify in your own defense or to remain silent and not have that silence used against you in any way. Do you understand those rights?
Yes, Your Honor.
Do you have any questions for me or your lawyer about any of those rights?
No, Your Honor.
Do you wish to give up those trial rights and enter a plea here today?
Yes, Your Honor.
If I accept that plea, you give up any claim that it was caused by promises beyond the plea agreement or by any threats. Do you understand that?
Yes, Your Honor.
Also, by pleading guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission to appeal. You would do so by filing an application. And the types of issues you could raise on an appeal after a plea are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, Your Honor.
All right, the plea agreement provides, as your attorney outlined, in exchange for your plea to count 1, delivery of methamphetamine, prosecutors dismissing count 2, the drug double enhancement and the habitual 4th enhancement, restitution is agreed upon at $100. Do you understand the terms of that agreement?
Yes, Your Honor.
Other than that agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you to make you?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 1, delivery of the controlled substance methamphetamine?
Guilty, Your Honor.
So, Mr. Pulowski, back on November 14th of 2024, were you in Sheboygan County?
Yes, sir.
And did you deliver controlled substance methamphetamine to a person that later turned out to be a confidential informant with law enforcement?
Yes, Your Honor.
Did you know that you were delivering the controlled substance methamphetamine?
Yes, Your Honor.
And you're not a doctor or pharmacist. You have no right to dispense that substance. Would that be correct?
Exactly. Yes, Your Honor.
All right. And that delivery occurred in Sheboygan County?
Yes, Your Honor.
Mr. Niagos, you satisfied with the factual basis?
I am, Your Honor. Thank you.
Ms. Goodrich?
Yes.
And Mr. Niagos, are you aware of any other promises, threats, or inducements?
I'm not, Judge.
And do you believe I fully complied with the requirements of MCR 6.302?
You have.
Ms. Goodrich, do you agree?
Yes.
All right, Mr. Pulowski, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you are guilty of that offense. So I hereby accept your plea. We'll schedule sentencing in person. Mr. Niagos, I could give you October 7 or October 21.
October 7, Judge.
Okay, do you prefer morning or afternoon for an in-person sentencing?
Mid-morning, if possible.
Yeah, I could do 11:10 a.m.
Thank you, Judge.
Okay, so that'll be October 7 at 11:10 a.m. That'll be in person. You have to cooperate, Mr. Pulowski, with an updated pre-sentence report. I'll just continue the the contempt hearing for the same date and time.
Judge, I discussed, if I may just briefly, Your Honor.
Yeah,
I talked to my client, and I think he's frankly surprisingly realistic as to the situation. We've discussed my anticipated guidelines in this case. He's aware that a lengthy prison stint is coming. He's also, frankly, to his additional credit, the one that brought up the issue of contempt regarding an earlier bond violations to my attention. That being said, Judge, I frankly told him that it's unlikely the court would speak and or give him one final opportunity, but I promised him I would try. Mr. Pavlovsky indicated to me that he's got some affairs that he needs to take care in terms of making arrangements for his homestead and the such, as well as some familial relationships. I have these guidelines, Judge, calculated at best 72 to start, at worst 84, at best 120 on the bottom number, at worst I believe 140 or 150. So certainly, if the court was to somehow, some way take a significant, and I do understand what I'm asking for, significant leap of faith to give him a couple weeks to take care of these obligations, should he be non-compliant, otherwise be on the run or have any additional drops, obviously the one person who would suffer more than anybody else would be Mr. Pavlovsky, given that, you know, the best case scenario for him would turn into likely closer to the worst case scenario, or worse, given his prior criminal history, the court could exceed those guidelines. So knowing that he's got all this hanging over his head, Judge, my client wanted me to make it an attempt to see if you'd be willing to give him an opportunity back in the community for the next few weeks. But in the event that you don't, he understands his conduct has brought him before you, and he takes full responsibility for it. Thank you.
thank you, Mr. Niagos. That's an outstanding pitch. And you're right that, you know, if Mr. Pulowski has any hope at the low end of the guidelines, then certainly if he didn't show up, he'd be looking at high end of the guidelines. However, I've been burned by Mr. Pulowski before. We had him in a treatment court where he was non-compliant. I'm just afraid with these guidelines, if I cut him loose, I'm going to end up regretting that. So I'm not going to do that. Post plea bond is entirely discretionary anyway. But the good news, Mr. Pulowski, if you've been discharged from parole, that means you're no longer sitting on dead time right now. So at least you're going to get credit.
Okay.
I know that's probably some cold comfort to you right now, but I'm going to order him to continue to be held without release. All right, we'll see you October 7th at 11:10 a.m.
Thank you, Judge.
All right, thank you.
Okay, thank you.
Take care, Steve.
Thank you. Thanks to you.